I didn't wear a tie, so I hope this sort of matches. If it draws attention away from the belly, it's doing its job. Chris Dillon, good to see you again. Nice to see you. Well, good to see you. Thank y'all for coming. Thank you. Thank you. Good afternoon. Welcome to your North Carolina Court of Appeals. My name is Chris Dillon. I'll be presiding today. And to my right is Judge April Wood. And to my left is Judge Jefferson Griffin. Eddie Sanders is our clerk today, and Richard Remillard is our marshal today. So we thank you all for being here. We have one case on the calendar, very interesting case, Brewer versus Rent-A-Center. And if you're ready to proceed, we'll hear from the appellants. And just let me know how much time you want to, you can go ahead and approach, but how much time you want to reserve for rebuttal, and I'll keep your time here. You can pay attention to that, but I'll kind of give you warnings, because sometimes you'll get near to the end of your time, and we'll start firing questions at you.
Right.
I always want to make sure you have time to at least wrap up what you want to talk about. So that's sort of a guide, but I'll kind of keep you posted. So do you want to reserve any time?
I'm going to try to reserve 5 minutes.
Okay, that's fine. Okay, we're ready. Go ahead.
May it please the court, my name is Dwayne Jones with Hedrick Gardner, Kinchlow, and Garofalo. With me is Brendan Kumalander. He's an associate in our office. We represent Rent-A-Center in this matter and their workers' compensation insurance carrier. The main issue today, and what I would argue is the sole issue, although I suspect that we're going to get into some ancillary issues, is that the full commission erroneously determined that the expert evidence presented by defendants in this matter through Dr. Novak and Dr. Young, that evidence was not competent and not sufficient to rebut the Parsons presumption.
So you would concede that if the full commission weighed the evidence, then y'all lose. Your whole issue is they never got around to that because you're saying that they said it was incompetent. Is that basically the issue? is whether they.
Yes, just,
Did they discount your witness because they thought they were incompetent, rather than they just didn't give it much weight? Is that what it comes down to?
well, two parts, yes, that is what I would contend that they did, and I think the opinion and award shows that with the findings of fact and the conclusions of law. Two, even if they did weigh the evidence, and I think that's what I will get into, is that at this stage of applying the Parsons presumption, there's really no weighing of the evidence that would go on sort of in the traditional sense that this court normally, you don't disturb the full commission's weighing of the evidence. They get to.
Well, could your client bring forth evidence, and they'll say, yeah, that's competent, and it would rebut it, so you've met your burden to rebut it, but we give it no weight, and so, so the other side does the other side have to do anything if they decide to give it no weight? Because that would be a factual question.
My argument is.
Go ahead.
My argument is going to be that in this stage where defendants have to come forward with competent, legally sufficient evidence to rebut the presumption, if we do that there's not really any weighing, there's an assessment of whether it's sufficient, but there's no real weighing.
Right.
If we do that, the presumption is rebutted, then you move on to the second stage, and they can take my perfectly competent, sufficient evidence and say, we assign it no weight, we assign plaintiff's doctor who says this is compensable greater weight and fine for the plaintiff.
Well, didn't the commission find that there was competing, expert testimony, and therefore the defendant didn't rebut the presumption because they found that it seems like they just didn't find the evidence credible?
Well, they didn't say anything about credibility. They said competency and insufficiency, and I think there is a distinction there. And to answer your question, I think if I got it right, no, they can't weigh the evidence at that stage. They can't weigh competing evidence at that stage. The only burden that defendants have to rebut the presumption, and when you look at the Reniger case, the Perez case, the Gonzalez case, they all speak in terms of defendants have a burden of producing evidence, defendants have a burden of showing. So defendants come forward with evidence. Again, it has to be competent, it has to be legally sufficient. I mean, it has to meet all the things in Holly and all that kind of stuff. But once you do that, the presumption is rebutted, and then you move on to the second stage. The burden is returned to the plaintiff, and then you certainly, the full commission, and we've conceded that in our brief, has every right to weigh the evidence, say that this physician is more of an expert, or we take their opinion to be greater.
Is it possible that you could put forth your evidence to rebut the presumption, the plaintiff put forth nothing, but the plaintiff still win because the commission says, okay, we're going to weigh it, we don't really give it much credit?
No, that's not possible.
That's not possible.
That is not possible because the burden would, if we rebut the presumption, the burden would have shifted to the plaintiff.
Then there's a presumption that they lose, and they have to come up with something.
Yeah, I mean, I wouldn't call it a presumption, but the burden of proof, again, when the whole thing starts, at any day one of any comp case,
Okay.
it's always the plaintiff's burden to prove the injury is compensable.
But in this case, they did put forth some evidence, but you're saying they never got to that stage. Is that correct?
Well, I would say that they didn't put forth sufficient evidence to prove causation, but that's, the full commission never got to that point.
Well, that would be my question. Is it possible that the commission said, if it's, whether it's competent or not, even if it is competent, if we treated it as competent, we're not going to answer that question. Well, you're saying they did answer the question. I'm just trying to think, is it possible they could also say that?
I think,
even if it's competent, you still lose because in weighing it, we don't give you any, we think the other evidence.
they could do that. They
Just didn't. You're just saying
they did not do that. I mean, again, I would say theoretically they could do that. In this case, my argument is going to be they can't do that because the plaintiff did not come forth with their sufficient evidence. But theoretically, yes. And I think that that's how, sometimes the cases get a little bit commingled up because, and these stages get a little bit blurred because, yes, oftentimes defendants come up with evidence. We all have our doctor that says it's not related. Plaintiff has their doctor that says it is related. The way the presumption should work is defendant's evidence rebuts the presumption. You shift to the second stage. You take my doctor, you weigh it against the plaintiff's doctor, and at that point in time.
So if you rebut the presumption, that doesn't mean you win.
Absolutely.
Because I'm reading now the conclusion law 3, and the present matter defendants have failed to rebut the Parsons presumption. And so the only issue before us, did you present at least some evidence that would be, that would rebut it?
Some competent, legally sufficient evidence to rebut the presumption, yes.
Well, didn't the commission find that they just didn't believe that Dr. Novak, I mean, they made a finding that Dr. Novak doesn't treat patients clinically, is not board certified in pain management, does not, or did not examine plaintiff, did not provide any treatment to plaintiff, and has never met him. And then they go on to say that Dr. Novak said he's got some sort of unidentified autoimmune disease and that his current condition can't be related to his work injury, and that the commission just discount that?
As a matter of law, those reasons would not discount the evidence. They would not render that evidence legally insufficient. They would not render it not competent. If we get to the second stage, all of those reasons can certainly be why they pick Dr. Maxey or Dr. Tiffany or the opinions of another doctor over the opinions of Dr. Novak.
Well, let me ask you a question. So I think this is an issue in your case. Let's say I fall off a ladder at work and compensations, I mean, I get benefits. And so basically it's established in the first instance that, yes, my injury to my back was caused by me falling off the ladder. 5 years later, I have the same injury, and your expert says, I don't think that falling off the ladder caused the injury in the first instance. You're saying that doesn't necessarily render your evidence incompetent?
Again, two things. That's not what my doctor said in this case, and two, it would not render it ineffective.
Okay. Because I thought you talked about, well, there may be a factual finding, but not a legal finding or something like that. I thought you talked about
Right.
but is that what the commission based it on in part? That
I think so.
That your witnesses said, we don't think that that's, I mean, your witnesses said that they didn't think that the fall off the box caused the injury in the first instance. I'm not saying that's what, you're going to argue that's not what your witness said.
That's correct.
Okay. So that finding is not supported by the evidence, or that?
It's not supported by the evidence, but it's also not supported by the law because there was no fact ever deemed to be a fact. And
Well, talk to me about that, because there's the whole issue of the Form 63.
the Form 63, Section 1, which we did not deny within time, we've conceded that transformed into an award of the commission. And 9782 says that establishes the compensability and the liability. It does not establish any facts. There's no facts established other than something happened on this date and we were responsible for paying medical treatment for it. It might be different if there was an opinion and award that had came out and said, we find this fact occurred on this date. So I get how it gets sort of closed.
Well, don't you just concede that there was a work-related injury and it was due to whatever the plaintiff put on the Form 63, and that's why you're paying the damages and the award?
Well, and again, I'm not trying to parse out too much here, but my position is that there is no fact that was established. Obviously, compensability was established and the liability of defendants are established, and we have to pay medical compensation until we come forward with sufficient, competent medical evidence to say it's not related.
I guess it's similar to, like, if you sue me and I don't answer, you can get a default judgment, but can that be used as a statement that I made in any other action? I don't think it could, because I haven't admitted anything. It's just deemed admitted as a matter of law. Is that sort of what you're saying? It's just sort of deemed as admitted, but it can't be really used for any, though in this case we're in the same action.
Well, I haven't thought about the legal consequences of your analogy, but it sounds to me like, yes, that's exactly what I'm saying. It doesn't establish anything other than the compensability. But the point that I would like to make is when you look at the testimony of Dr. Novak and Dr. Young, I don't know that either one of them ever testified, I don't believe an injury ever occurred. And none of them ever testified, well, anyway, when you look at their testimony, it is, Dr. Young testified, whatever injury happened on this date, it is no longer causing the symptom. So that's how his answer
They're looking at this injury that they see today, and they're saying that wasn't caused by it. We don't know what injury he might have had back in 2010. No. You're just saying the injury here. That's
right. They based that upon all the MRI studies and the other film studies that were done. I think they were all MRIs, but so he says that then on page 19 of the deposition, the question is prefaced. He said, based on the imaging studies and review of the medical records, I cannot relate and explain Mr. Brewer's injury of 7/1/2010 to those studies. I cannot relate that injury to the many symptoms that he is currently experiencing. Then he's asked the question, so put another way, if Mr. Brewer is experiencing pain symptoms today in his neck and back, is it your opinion that those current neck and back pains are not causally related to the July 2010 work event, not on the basis of the MRI scan? So they never presume that I don't believe anything ever happened, therefore nothing can be related to it. They base all of the questions, especially, well, yeah, just read the deposition. I'm not going to read it all to you because it goes from about 8 to 19. Every question is prefaced with based upon the MRI, based upon the MRI, based upon the MRI. So every opinion that he elicits is grounded in not, I don't believe it ever happened, but in these MRI studies do not show an acute traumatic injury. Thus, whatever he's experiencing today is not related back to that. And I think Dr. Novak she ties everything to the imaging studies that he had on when the incident occurred, and all the subsequent imaging studies thereafter have never evidenced an acute injury. Therefore, what he's complaining about today is not related to what happened in 2010. So again, I dispute the fact that specifically with Dr. Young, the full commission found that the sole basis of his opinions was that no injury occurred. And that's factually wrong. And two, it would be okay, yes, I would argue that it would be okay if he did, because there is no conflicting fact already established by the Industrial Commission simply by the acceptance of the case on the Form 63. Y'all peppered me with quite a bit of questions there, so I got a little bit lost, but I'm going to take a breath to see if you have any follow-up questions.
Well, finding of fact number 38 wasn't contested, and it seems that the commission actually put in Dr. Novak's testimony that the number one basis is he doesn't have imaging studies to support that. His imaging studies are basically negative and have been from the very beginning, and it seems from that the commission got that she denied he ever had an injury as of July 1st, 2010.
Well, I'm confused about how you're extrapolating seems to have gotten from that. If then that's still...
Well, there seems to be further findings of facts that aren't contested that explicitly state that he had an injury on July 1st, 2010, and because of that, he had to have surgery because of the July 1st, 2010 injury. And it appears that the commission is noting that Dr. Novak said we didn't have an injury from the very beginning.
What part of finding of fact 38 are you saying she did not have an injury from the very beginning?
Block quote.
The second line.
Right, but she doesn't say he never had an injury on that day. She's saying that the imaging studies do not show any acute traumatic event. And if, in fact, he had a serious injury that would still be causing problems some 10 years later, that, yes, on this MRI, I should have been able to see something there. It's not denying that he didn't have an injury. I mean, I think she could say he didn't have a serious injury, nothing that would show up on the MRI. So, again, to answer your question, I don't think that they found, or I don't think that she based her opinion on there's no injury. And you know, I would say that...
The commission found that she based her opinion on there's no injury.
But that's not based on any fact. And I don't think that you can look at that paragraph and say, well, it wasn't on the imaging studies to extrapolate from that. Dr. Novak did not believe that an injury occurred. She clearly did not believe an injury occurred serious enough to show up on an MRI.
Well, then we're just substituting our judgment for that of the commission at this point, then.
No, you're not. No, I respectfully disagree. But and again, I would say that in this case, when you look at the Hoponsky case, determining whether the evidence is competent is a question of law. That's what I'm asking you to do. And determining whether the evidence is sufficient to establish causation or rebut the causation is a question of law. That's what I'm asking you to do. And so by virtue of the fact that any time any one of us comes up here and says, look at the causation opinions, you are asked to go back and weigh that causation opinion. I think, I don't know how many causation opinions I actually cited in the brief, but I know I cited to Holly, and the Supreme Court went back and looked at the full commission's determination of this injury is sufficient to establish causation, and they went back and said, no, it's not. They did not go back and say, well, I can't look at it because I can't weigh it. So again, I'm going to rely upon the Hapnowski case and say, Judge Wood, yes, I'm asking you to substitute your judgment in this case because the law says that you can, the law says that you should, and if you were determined, was Dr. Novak competent, and was her testimony legally sufficient to support causation or rebut causation in this case, pursuant to the cases of Holly, was it to a reasonable degree of medical certainty, then yes, you should reverse, and I'm asking you to reverse.
Is it accurate to say that she said, I'm not really sure what caused it, but I just know the fall didn't cause it? Could have been some lupus or something. And that's okay, as long as her testimony said, I know that didn't cause it, that fall caused it.
Yes, and again, to differentiate Dr. Young and Dr. Novak, the full commission just said that he didn't believe that it occurred, but with Dr. Novak, they went on and said, she's just guessing. No, she's not guessing as to it is not related to the fall. She's then asked, I mean, a lot of this was in the first part when they're talking about fibromyalgia, and she's like, look, I don't know what all he's got going on here, but none of these things have been ruled out, so I'm not going to say it's fibromyalgia. Later, she says, she offers, I think it may be these things, but again, that doesn't somehow render her statement to a reasonable degree of medical certainty based upon the MRI studies. I don't think that what he's going through now is related to his original injury. It does not render that speculative by trying to look over here and say, well, it may be this, and that's what she was asked. What do you think may be causing these things?
So now tell me why you think that their expert didn't even meet their standard. Assuming you rebutted it, why do you think that their expert didn't?
Is everybody good on that, or at least for the hypothetical situation that we've rebutted? It was there is a distinction when you move from one stage to the next.
I understand. Yeah, I understand that.
So your position is that the Parsons Presumption, conclusion of law, that we can review de novo, correct?
Yes.
Okay, all right. So that's,
You can review whether it's competent and whether it's legally sufficient to, in this case, rebut causation pursuant to the standards in Holly. And so if you do that, and again, I think in our reply brief, and to be clear about that is, that's an error of law. That's what I contend. Certainly at that point, you can remand it back to the full commission and say, look, you screwed up on this conclusion of law, fix it, and then go forward.
But you would say that if they didn't produce any evidence to rebut it, you automatically win. Isn't that what you told me?
I didn't.
You automatically win. If you've rebutted the presumption, they put forth no evidence.
And yes, that's what I would argue.
And then you said, I think at the beginning of your argument, that they didn't put forth any real evidence.
They did not put
opinion. So you would automatically win, I guess. So I'm asking you,
yes.
Why do you say that their expert is no good?
Because all of their evidence is guesswork. No one says to a reasonable degree of medical certainty that the current symptoms, the current treatment that he's being prescribed is related to the original injury. There's not one doctor that says that. I mean, it's all of them.
Well, you didn't raise a challenge to finding of fact 41, and finding of fact 41 says Dr. Young ultimately agreed he was not offering an opinion regarding whether plaintiff's current need for pain medication is related to his original injury, and that imaging studies are just one part of determining a patient's diagnosis.
And again, Judge Wood, respectfully, the part about the imaging studies, yes, and I think that would go to the weight of his testimony at the second stage. And so, if Dr. Maxey, the orthopedist, have said to a reasonable degree of medical certainty is related, we adopt Dr. Maxey and we discount or discredit or assign lesser weight to Dr. Young because he just looked at the MRI. That would be certainly fair. But again, going back to that it does not render it incompetent. It does not render it legally insufficient. And so
did Dr. Young say that I think that the injury, that his current condition is not caused by the Dr. Young
Yes.
give that same, Dr. Young did give an opinion in
Page
my,
14, page 19, page 22 to 23.
and you're saying 41 doesn't contradict that? Finding of fact 41 doesn't.
He would not go into the medications, but he says that the current, the symptoms that he is complaining of are not related to the work injury. He's being prescribed medication for the symptoms. So I would say,
He gave
even
that
when he
opinion.
did say that, he's, again, the issues, the medical issues that he is having right now are not related to the injury. Yes, Dr. Young stated that he would not venture into, I'm not going to get into what prescriptions he says.
Well, he also, number 42 says, when asked about his deposition in 2020, Dr. Jones declined to offer an opinion regarding the cause of plaintiff's current symptoms or the need for treatment. He indicated he would defer to a pain management specialist regarding whether plaintiff's current medications were appropriate, and then talked about 15% of patients have residual pain from surgery.
But Dr. Jones, I would agree that that's what Dr. Jones says, and I haven't relied upon Dr. Jones' opinion at all to say that it is not related. I don't think there's anything in Dr. Jones's deposition that says it's not related.
But don't you have conflicting evidence here, conflicting test witnesses, expert witnesses that talk about why he has pain and what it's from? You have Dr. Jones saying, I don't know. You have Dr. Maxey who says it's related. You've got Dr. Novak who says it's not.
Dr. Maxey did not say it was related. Dr. Maxey could not render an opinion to a reasonable medical certainty that it was related. No doctor rendered an opinion to a reasonable medical certainty.
They either said it didn't cause it or they didn't know.
Yes, and that's the crux of
And nobody
why.
really knew, nobody otherwise really, none of them really knew, but I guess maybe accurate ways, none of the doctors really knew what caused it. Two of them just said definitively, I know it wasn't the accident. The other
Yes.
two hadn't. So that's probably, nobody really knew what was causing it. It's just two of them, your two witnesses just said, I know it wasn't the accident.
That's correct.
Okay.
That's sufficient to rebut the Parsons presumption that places the burden of proof on plaintiff, and with the burden of proof placed upon plaintiff, he cannot point to a doctor that conclusively says, or to a reasonable medical certainty says, that it's related. Yes, ultimately,
You have
defendants
about
win
2 minutes
because of that.
before you eat into your 5 minutes. So you still got 2 minutes before you eat into your 5-minute rebuttal.
I mean, I may have touched on everything. I mean, there's some details that I've,
You can reserve 7 minutes if you want to. Just whatever you want to do.
again, when you get to what it takes to rebut the presumption, I do want to, sometimes, and I think that the full commission didn't do this, maybe because they didn't get to it, but I don't think they would have done it anyway. But certainly plaintiff is going to say that the burden of proof is on defendants at this stage. And I would contend that it is not, and it is a burden of production, it is a burden of showing, it is a burden from the Renninger, the Perez, the
Is there a
Gonzalez
case that
case.
says that law's got to be settled, but I
Well,
I didn't do work.
there's nothing that comes flat out and says it is an evidentiary presumption, although the courts treat it as it's an evidentiary
So
presumption.
you say the law is, if you rebut the presumption, then you win unless they can come back and say.
Yes.
But they might say, no, it just means now you go to the second stage and they could give your witness no credibility.
I would say that. But all I have to do is come forward with competent, legally sufficient evidence to rebut the presumption. I don't have to win the day. I don't have to win it by preponderance of the evidence. It is not a burden of proof on me.
Because initially the burden's with the injured employee to show that they're entitled to coverage.
Right.
So you're saying
We accepted it. There's a presumption that applies to me.
So it just starts you back at square one that they got.
You're saying we're not reweighing your evidence to go forward with the presumption?
Yes.
Yeah, you just had competent.
I put forward the evidence. Despite what the full commission said, it is legally competent, it is legally sufficient, the presumption is rebutted, we go to the second stage, and
At the second stage, they can tell you to go kick rocks or do whatever, right? They can weigh the evidence however they want at the second
yes,
stage. Yeah.
they can. And again, had they found that Dr. Maxey testified to, if they had actually found Dr. Maxey testified to a reasonable medical certainty that it was related, I would be up here pounding the thing, saying they did it wrong, but that I would lose anyway. But yes, I do think that the procedure is important to follow and it's important to set out. And when you look at the cases, they do treat it that way. And especially I think it's the Perez case When they refer to defendants, they talk about a burden of showing, a burden of production. When they talk about the plaintiff, they talk about a burden of proof. I do think that that's important distinction, and I think it shows that, yes, and again, it doesn't even make sense if the burden of proof is on defendants and we prove that it's not related, all the cases then say, and it shifts to the plaintiff. Well, if we've already proven it by a preponderance of the evidence, how can the plaintiff prove by preponderance of the evidence that it's actually related?
Okay.
So that's why and I know my rebuttal time is running out, but yes, I'm not asking you to reweigh the evidence, Judge Wood. I don't think there is conflicting evidence as to what our expert said. I think that it is legally competent, legally sufficient. It should have rebutted the presumption. That's the main error that the full commission made. Yes, in your hands right now, I do think that you have the authority to go forward and say, and there's nothing that plaintiff has offered to show causation, defendants win.
Thank you. Here from the appellate.
May it please the court. My name is Kristen Henriksen of Cardinal Law Partners. I represent the plaintiff appellee, Mr. Robert Brewer. I've represented Mr. Brewer for about 11 years at this point. Just a couple of brief facts about Mr. Brewer's case. He did just have an admittedly compensable injury. In July of 2010, he fell about 10 feet from a stack of boxes. He was working as a store manager at a rent-a-center at that point. He had been employed there for about 9 years. But the issue we have before us is the Parsons Presumption. Prior to litigating this claim, defendants filed a request for a hearing in August of 2019, which was about 9 years after Mr. Brewer sustained the original injury. Defendants submitted the claim, they provided treatment. Every physician that is in the record, other than the experts retained by the defendants, are authorized treating physicians that were selected and authorized by the defendants. Mr. Brewer treated with a number of physicians over the past 12 years, but most notably are Dr. Maxey, who is the orthopedic surgeon who performed a cervical fusion in 2014. He is with Emerge Ortho of Hickory. He's board certified in orthopedic and spine surgery.
Let me ask you a question.
Yes.
Is it accurate to say that every doctor that testified, nobody testified that they knew what caused the injury, but they had two experts that said, we know it didn't come from the accident? Is that accurate? Did anybody say, I know, it's my opinion that the injury's causing these things? Or did none of them have any idea what caused it? It's just that two of them said their opinion was it didn't come from the accident. Is that accurate?
I don't believe that's completely
Okay,
accurate.
so what doctor would you say that would not apply to?
Dr. Maxey. When we deposed Dr. Maxey, he testified, and he differentiated his testimony as to the cervical spine versus the lumbar spine. He operated on the cervical spine. He did not operate on the lumbar spine. Dr. Maxey.
So Dr. Maxey says there's a finding, could not determine the cause of the lower back pain. Okay.
He did. He testified more specifically about the cervical spine because he did surgery on that body part. And he did say that there was objective findings with the cervical spine, and he could relate what was going on to the cervical spine. Now, the other doctors that were seeing him,
Dr. Maxey saying, I think that the cervical spine pain was caused by the accident.
Yes, he said that. He differentiated his causation findings when you had the cervical versus the lumbar spine. He talked a good bit about post-surgical pain and
So you would say no witness knew what happened with the lumbar, but you had a witness that said that the cervical spine part was caused by the accident.
I would say exactly what they said is Dr. Maxey also further testified that he believed what he was treating the plaintiff for was related. He could not get as specific with the lumbar spine. He said, I have trouble determining the current cause of the lumbar spine. Dr. Gingrich, who's the current pain management provider, was deposed. He is the most recent treater and the current treater. He came into the picture in 2019. So he came in March of 2019, 9 years after this individual had been injured. and I'll discuss that once I finish answering your question. He testified that because he was seeing the person so long after the original injury, it was hard for him to say specifically, but we talked a lot about the symptoms and.
But would not give an opinion. But he would not give that doctor did not give an opinion one way or the other.
He did not give a causation opinion, but what he did say was that he also could not say that it was unrelated.
Yeah, so, but I understand. Do you think that the defendant at least met their burden to rebut the Parsons? Did they put forth competent evidence which a fact finder could use to say, yeah, that doesn't cause anymore? Just by having a doctor review records and say, in my medical opinion, I don't see that the accident caused these injuries. Did they at least rebut the Parsons presumption?
I don't believe that they did. But I don't agree with the defendant's legal analysis of Parsons. If you look at Perez.
So what would you say? Yeah, so tell me how Parsons works then.
Parsons it creates a rebuttable presumption in favor of the plaintiff that the additional medical treatment sought related to only the compensable conditions listed on the Form 60 or 63. Getting out of the Wilkes line of cases, we are dealing with only things that are admitted in the case. They enjoy a rebuttable presumption that those things, the treatment requested for those conditions, is related to the original compensable injury. Purpose of that, and I think this case illustrates exactly why we have Parsons, is that this case was admitted now 12 years ago.
I understand. So they did put forth witnesses that said we don't think that the current conditions was caused by that accident. So why wouldn't that be, or did they not say that? Why would that not be evidence or some evidence if they're doctors and they're experts?
I think there's a difference in did they put forth some evidence and what does the Parsons presumption actually say and how is it applied?
So what were they required to do? What kind of evidence were they required to put forth? Just simply to rebut the Parsons presumption? Not to win, but just to rebut the Parsons presumption?
I think it requires a step back. The Parsons requires the presumption, and pursuant to Perez, pursuant to Gonzalez, this case is extremely similar to Gonzalez. If we look at McLeod versus Walmart, the court enters into a discussion in each one of those cases where they talk about the Parsons presumption, and in my opinion, the two-step analysis is one, does Parsons apply? There's a 63 uncontested, so yes, it does.
Okay.
Then the commission the commission receives all the medical evidence of expert testimony, just like they would in any other case. I don't agree that there is a two-step analysis. I agree that Parsons applies and a rebuttable presumption is provided to the plaintiff. Defendants may come forth with any medical evidence that they would like to produce, but then it is up to the commission to weigh, and in their sole discretion, to weigh that medical evidence and decide, does that evidence rebut the Parsons presumption? There is no case law that supports defendants' argument that it's just automatically rebutted.
I could see
if you
in
produce
general,
any-
though, there could be a competency issue. And let's just say there was a rule that, I assume that a doctor from California could come and be qualified as an expert here. But let's say that some doctor from California came and testified, whatever for the defendant. And the commission said, you know what? I think the law is that anybody else that doesn't have a North Carolina license isn't competent, so we're not going to consider it. And so therefore, we don't think the Parsons presumption was even rebutted because you didn't put forth any competent evidence. That would produce a question of law for us to say, no, you should have considered it. And your friend's argument is that they really didn't consider it because they said it wasn't enough. They didn't get to the weighing stage because it wasn't enough to meet the presumption, I guess. Maybe that's not an exact analogy. But maybe it is, because I think wasn't there some kind of sense that since these doctors say that there was no accident at all or no injury at all, we're not going to consider anything they say as a matter of law. We're just like the California doctor. We're not going to consider the California doctor because we think the law is, if you're from California, we don't even look at it. So, there is a question of law there at some point. So why is that not an issue here? Why is there not a question of law we need to determine? Did the commission properly at least consider and weigh the evidence that they offered, or did they just discount it totally because they said it wasn't competent? Because they used the word competent. They're not competent, was not competent to rebut, and that is something I'm sort of stuck on. And do you think it wasn't competent? Maybe you think as a matter of law it wasn't competent, or do you think it was competent, just they weighed it? I'm trying to figure out, what did the commission do? Did they weigh it, or did they just say at the get-go, it's not competent, so you lose?
So let me just
Yeah, help me.
ask, It looks as though in other findings, they clearly say, based upon the preponderance of the evidence and in view of the entire record. So based on their own language, it seems as though they weighed the sufficiency of the evidence. So do you agree with that, or do you think that that is the wrong way for them to address the sufficiency of the evidence, on the preponderance of the evidence?
I agree that they weighed the evidence. I think if you look at the full commission's findings, when you look at 38, 39, 40, 41, 42, and then you go into 48, 49, those are all pertaining to Dr. Novak and Dr. Young. It is very clear from those findings that the commission entered into a very thorough review of those doctors' depositions. They made very specific findings that show that they did consider those things. They didn't just toss them away and say they are not competent, therefore we are not going to consider it. They clearly considered it. They made very detailed findings of fact about it that support, and those findings of fact are absolutely supported by the deposition testimony of both of those doctors. They testified to the things that support those findings. So I think that...
I guess why would we even have a presumption, or this Parsons presumption, if they're just going to put it all in a pot and stir it around and weigh all of it either way? Why would we have that presumption?
I think for the same reason that they weigh any evidence, it's similar to the plaintiff's original burden of proving compensability. This is a similar burden. If the claim is denied and the plaintiff comes to the hearing, the plaintiff may present evidence, the defendants will present evidence, and the commission considers all of that and provides weight and provides greater weight to some than the others. The court in Gonzalez talks about this a good bit when they're weighing, I believe, 2 to 3 medical experts, and there was one doctor who had seen the plaintiff one time and was talking about having a psychological cause to the pain. And there is a reasoning for the court, and they said, let's assume, even if this doctor's testimony was sufficient to rebut the Parsons presumption, the commission has discredited it, as it's allowed to do. And I think that's the commission's authority at any stage of determining whether it's compensability or a rebuttal of the Parsons presumption, which is sort of a reverse compensability. They're similar burdens, and at either of those, the commission takes a plethora, I mean, in this case, a lot of medical experts into consideration. And
But they said it didn't even apply here, right? They didn't even apply it, right? The commission, the presumption? They did apply the presumption. They stated the presumption applied. They weighed the evidence, and then they found that Drs. Young and Novak were not sufficient. And to answer the question of competency versus sufficiency, and this is language I see a lot in commission decisions, I think that they sort of interchangeably use some of these terms, and you'll see them do this quite a bit. I don't believe they mean an issue of legal competence. I think they're trying to tell you that they weighed the evidence. They did not find this evidence to be sufficient, credible evidence to rebut the Parsons presumption. I think the flip side of this is when you look at the Parsons presumption, if you go with the defendant's argument of this is how the Parsons presumption applies, realistically what you get is a situation that would apply to a plaintiff on initial burden of proof and a defendant on the burden of Parsons, that either party can produce whatever evidence they want, and then it's automatically rebutted. So why even have a Parsons
Did Dr. Young or Novak, and I'll go back and look at it, did they testify that your client did not suffer an injury on July of whatever, 2010? To the cervical or lumbar. Did they defend, is that what they said? Did they say that, or did they just simply say, what we see here, that wasn't caused by it?
They said that the imaging studies did not reveal any acute injury. That was the language that they used. Dr. Young, when we deposed him, he said that multiple times. He reviewed MRIs and said, I don't see any acute injury. He also later admitted, I can't see things like post-surgical pain or aggravation of pre-existing conditions or other things.
But they did not, well, my question, did they testify that your client did not suffer an injury in 2010?
I don't know if they used those exact words. They were saying the MRI studies did not show evidence of acute injury. I think that's
the commission's basing their conclusion on that. I'm looking at 3, and it says Dr. Young, basically, he testified because plaintiff suffered no injuries on blah, 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 any treatment, and then they said it's incompetent. And 4, it says Dr. Novak, she suggests first that plaintiff never sustained an injury to his lumbar spinal, and so, I mean, if that's not accurate, I mean, I'm just wondering, is that accurate? I'm looking at conclusion law 3 and 4.
I was looking back at some citations from Dr. Young, and each deposition was quite long and
I understand.
back and
I
forth
understand.
quite a bit.
I didn't go to med school. I understand.
He did testify that he did not believe that there was any injury that came out of that. He said the MRI findings are negative, there is nothing on there. I mean, that was the gist of what he was saying, is he wasn't factually present to say there was no injury, and he was careful to hedge away from things that were
But
not
he was
related.
looking at images that were taken at the time of the accident. Is that right? Did he go all the way back there? And so he said, I don't see anything here that would indicate that. Okay.
He had every MRI scan that was ever done, and he said, looking at those, there is no evidence of acute injury, injury sustained from this accident. And that's,
Did your witnesses say the opposite? Did they see things in the same things that their doctors looked at?
Yes.
Did they base their opinion on other things?
no,
So they're
this-
both looking at the same MRI, and one of them sees something, the other one doesn't see something.
That's correct.
That was just- that's me.
Doctors Maxey, Jones, and mainly Doctors Maxey and Jones were the surgeons in the case. And Dr. Maxey and Dr. Jones saw surgical pathology in the cervical spine, recommended an anterior cervical discectomy and fusion. If one has a negative MRI, fusion surgery is not recommended and performed. Both of those doctors agreed with that. There was a third doctor, Dr. Knapp, that also saw for surgery.
So all the doctors looked at the same MRI, and one of them didn't see anything, and the other one saw stuff.
That is
Wow,
correct.
okay.
Practically speaking, that does happen with depositions of doctors. One will say one thing, one will say the other thing.
I
But-
guess judges do that with the law sometime, too. Look at the
But
same-
that is, one said, I don't see any evidence of acute injury or anything in these early MRIs, and the other one says, well, I see enough to do a cervical fusion.
Well, let's talk about the rebuttable presumption and the fact that your client filled out a Form 63, and therefore you contend in that regards then that because the defendant didn't contest them, that those were deemed admitted, that everything in the Form 63 was deemed admitted by the defendant, and therefore his injury, there's a finding that his injuries were as a result of the fall from January 1st, 2010.
Yes, and actually, the defendants fill out the Form 63. So they're, either an attorney or a claims adjuster would be the one that chose those body parts and signs the form. And because they are the ones that chose what they were admitting, they admitted the neck, the back, and some other things, sternum, spleen, other things that were kind of acute injuries as a result of the fall. But yes, I mean, Parsons via Gonzalez applies to an undisputed Form 63, which becomes an award of the commission, just like a Form 60 or years back a Form 21. But that becomes an award of the commission as opposed to just those body parts.
The defendant, though, is arguing that just because they fill out the form and they don't ask for a hearing, it doesn't mean that they're saying that those injuries were specifically found, that there were facts relating to the injury, just that it was an injury that was compensable.
That is what they contend.
What is your contention?
My contention is a couple of things. I don't understand how one can admit that, and by legal definition, a workers' compensation claim that is compensable is an injury by accident. So they've already admitted an injury happened, an accident occurs, he sustains injuries as a result of that accident. I would also point the court to findings of fact 3 and 4, which are undisputed in the original opinion and award, which further establish the mechanism of the injury, the body parts involved. And then if you look at findings of fact 5 through 28, it details all of the medical treatment, all of the diagnoses that occurred. All of those are completely uncontested. So I think that even if it is true that defendants argue that, well, we filed the 63, we did not contest the Form 63, but all that says is that something happens and we have to provide medical treatment. I think that if you look to the undisputed findings of fact, it is deemed supported by the evidence that it describes what happened, how it happened.
But if I break my arm, one night, and the next day I come to work, and I'll go, oh, my arm hurt it. And my employer believes me, and so signs the 63 and goes with it. And so they've admitted it, and I get treatment, and I'm getting treatment, but then a few weeks later, there's a witness that says, I saw Judge Dillon, he broke his arm the night before, and I'm on video camera breaking my arm, and they get evidence. Are they just out of luck? Can can they now challenge what?
They can challenge. They have
Okay,
90
so why
days to
can't they do that
challenge.
here? They've admitted it, but now they've got some doctor that's looked at and like, you know what, we don't think that's what caused it. If that's what happened, why can they not do that here?
There's a limitation on the time period. So when they file the Form 63, they have 90 days to contest. They can get an extension for an additional 30 days, which is what a lot of carriers do. Instead of denying a claim, if they're unsure about the circumstances of it, they admit on this payment without prejudice form, and they have 120 days to investigate it and figure it out. But if they do not contest it at that point, then the commission,
So if a year later, my fake employer finds out that I faked it, they're just out of luck.
they would file a claim for fraud at that point.
I can see that. So, okay. That would be the exception. Okay.
That would be your avenue there, some sort of fraud or contractual issue.
But they would say, okay, we've paid all these years, but you're saying they're just foreclosed ever to challenge it to make future payments. It's just they're locked into that fact. But that's what happened. That your client was injured because of a fall.
I don't think that they're locked in. I think that there has to be evidence that the commission finds to be credible. In this case, there's issue with the type of medical evidence that is presented. This would stand for defendants can shop for any doctor they want to and find someone.
In this case, the commission found they weren't credible for the simple reason because they were doing what you just said they could do. You could bring an expert in to say, I don't think that's what caused it, and so therefore going forward we don't want to pay. And that's the very reason why the commission said that they weren't going to even consider their testimony, because they were doing what you just said they could do. Because I understood you to say that they could bring a witness to say, a doctor to come in and say, you know what, this didn't really happen, even though it's outside 120 days, but going forward, we don't want to pay, and that would be okay for the commission to, that doesn't necessarily, that they're allowed to argue that. If they are allowed to argue it, then why can the commission use that as an excuse not to even consider their testimony? Because they might have made that statement that we don't think that there was ever an injury to begin with. I mean, are they allowed to do it or not?
If I understand your question, are they allowed to present these doctors
Can
that
they bring
say,
a doctor in and say, I don't think that ever happened? Maybe it's outside the 120 days, so they can't go backwards and go back and get money from the past and get a claw back, but going forward, they can stop paying based on the fact that we now have evidence to show that that's not what happened.
I think if you're bringing forth evidence, like say a witness that says this person did not actually fall, then you've got a separate issue from a medical doctor. And I think anytime you have a medical issue, whether it's original compensability or rebutting the Parsons presumption, both sides present medical experts. Some of those are doctors that may have treated the plaintiff. Some of those are retained experts. Most of the time in the commission settings, they're doctors that are retained but actually saw the plaintiff and evaluated the plaintiff and then provided an opinion. But the commission is always at liberty to weigh all of that medical evidence and decide what do we think should be granted the most weight. And within that weighing, did the defendants rebut the Parsons presumption with the evidence that they have presented?
Assume they rebutted the presumption. What's the burden on the plaintiff at that point?
Once the presumption is rebutted, the burden is back to the plaintiff to show that the conditions are related. That is the burden on the plaintiff if the defendant successfully rebut it.
So what would these, in this case before us, what would they have to show to meet the presumption, to rebut the presumption, other than two doctors testifying?
Well, and it goes back to the weight. Like if you look in Gonzalez, if you look in those cases.
Right, but why are we weighing it at that stage if they, what's the point of having a presumption if they have to weigh the evidence before the presumption?
They're weighing the evidence to see if it rebuts the presumption. The presumption in all of the case law has not ever been if the defendants produce anything, then the presumption is rebutted and it goes back to plaintiff. That would it would take away the whole purpose of the presumption. The commission is always at liberty to weigh any testimony, whether it's a lay witness or an expert witness, and determine the credibility of that witness. And I would say that's the point of the weighing, is to determine the credibility, because in this case you had multiple treating doctors, you had 3 or 4 expert witnesses. I mean, they had probably 9 doctors before them, and they couldn't say, well, if you don't weigh some of them, then.
Well, let's say there's this new super imaging machine. Could they bring a doctor in to say, we've looked at this new, and can you bring a doctor in to say, I don't think that this injury was caused, or there's an injury there caused by that fall? Can that be evidence? You said that you could bring a witness in that said that no fall, but could you do that? Could that be some evidence?
They can, yes, they can retain any position they choose to.
And they did that, and it seems to me that the commission didn't weigh the evidence. The commission just said because they admitted it in the Rule 63, we're not even considered. I don't see where the commission weighed, did he really suffer an injury on 2009? Because now they're arguing we shouldn't have to pay the same, because now we know he didn't really suffer this thing. We may not be able to go backwards, and you're right, the commission can weigh the evidence, and okay, let's see what the doctors say. But it seems like what they're saying is, we're not even going to weigh it because they've admitted it on the Form 63, so we don't even have to address that. So tell me, should the commission have at least weighed that? Because that's their defense.
Ms. Hendricks, may I just ask
Yeah.
a quick question?
Yeah.
Because I think we're getting lost in what the Parsons presumption actually is. As I understand Parsons gives plaintiff the presumption that any additional, like here and now, any additional medical treatment is related to the original injury. So it presumes there was an injury, and any additional treatment thereafter relates back to that injury unless they can rebut it. And what I see the commission saying is, because of the Parsons presumption, they just denied there was any injury to begin with, and that is contradicted by the Parsons presumption. Is that kind of your understanding, or do you have a different understanding?
No, that is correct. I mean, the Parsons presumption, they've admitted the claim, they've admitted that an injury took place, they've admitted that an accident occurred. The Parsons presumption pertains to additional medical treatment, and that's what we're dealing with.
So they can no longer bring in evidence. I'm sorry, so they cannot bring in a medical doctor and say, okay, there's an injury, but that injury wasn't caused by the fall because maybe we have a medical, we got MRIs from 4 years before and he still had the injury. Can they do, so can they offer as evidence the fact that that the injury that's being complained of actually never did cause, even though it's more than 120 days later? Or is it just simply, they just got to show that whatever injury they've admitted to, this has nothing to do with the injury? Can they go back and say the injury wasn't the result of the fall?
No, Your Honor, they cannot. They cannot relitigate that
after
issue.
120 days unless there's fraud.
They may not relitigate that issue. I've had other cases that dealt with
Okay,
different things, and the commission has also found they may not relitigate the issues of the actual injury by accident and things that occurred. What we are dealing with Parsons is additional medical treatment. That's really what you're dealing with Parsons. An injury happened, it is admitted, does this treatment relate?
The only issue is whether or not this injury he suffered now is related to the injury that he had back in, and the issue is not whether that injury that he had back then was caused by the fall, because that's been conceded. That's what you're saying.
That has been conceded. That is not open for relitigation. However, I think that's essentially what the defendants would like to do here. I mean, I think that the original hearing was to address TTD and all, and that was also listed on the issues for this court, but it was not briefed. I mean, there was an effort to do away with all benefits, which hasn't been successful, but once a defendant admits the claim, they may not relitigate the existence of the injury or the acceptance of the claim. We are just dealing with, we're dealing with an individual who has chronic pain and is treating for that, and do these medications, do these recommendations from a pain management professional relate to the original injury? And so Parsons provides him a presumption that that additional treatment does relate, and the defendants produce evidence to rebut it, and the commission weighs that evidence to determine, does it rebut it? And I would point the court to the language that, especially in McLeod versus Walmart, Gonzalez, they both enter into a fairly detailed discussion of talking about multiple doctors when a Parsons presumption is evident, and weighing those doctors. The commission weighed those doctors, and this court did not go back and disturb the weighing, and they enter into that discussion of the weighing of evidence to determine whether it rebuts the Parsons presumption. Are there any other questions on those points? Just to sort of summarize the appellee's position, we obviously contend that the Parsons presumption was correctly applied by the full commission, that they clearly weighed the evidence here in numerous findings of fact, and they just discredited these doctors as they are entitled to do. Because of that, because the Parsons presumption was not rebutted, plaintiff continues to get medical treatment as prescribed by the authorized treating physician that was selected by the defendants. I know that in the defendant's reply brief, they talked about remanding the case to the full commission. I think the findings are evident that they considered all of the evidence before them. I don't think they tossed anything out I don't think there's any reason to remand it. I think the full commission was very thorough and clear in what they decided and why they decided it. Their findings are well supported by the evidence, and the conclusions are supported by those findings.
Thank you.
And if there are no more questions, then I will wrap it up.
Okay, I'm set.
Thank you.
You got about 4 minutes.
Thank you, Your Honors. First off, I'm not relitigating any issue in this case. You know, we accepted the claim. What's on the Form 63 are the body parts that we accepted. Judge Dillon, I think your analogy was right on point about the, you know, somehow subsequently being able to determine that, you know, actually the injury didn't occur, like maybe you do have the super imaging machine. You know, after 120 days, or if we file the Form 60 to begin with, we're stuck with it. And you know, we have accepted that injury, whether it occurred or not. You know, because we could erroneously file a Form 60. We could just file a Form 60 to be beneficial. You know, maybe one supervisor or somebody filed it, accepted it, and then the other one comes back and says you shouldn't have done that. Again, we are not out of the compensability of that claim, and the Parsons presumption would apply. But we should at least have the opportunity to present some evidence that should be deemed to be competent evidence that, well, wait a minute, actually, I don't think anything ever occurred. And Judge Wood, to your point, even if you reject that, Dr. Novak, again, we talk about Dr. Young, and you ask Ms. Hendrickson if he said it. She said he did state that he believed it never occurred, but she didn't give you a cite. I gave you, I think, about 13 pages of straight deposition, every question prefaced with, based upon the MRI report, which should be credible evidence that he's not making up facts contrary to the commission. But I'll even go to Dr. Novak. She definitely didn't say it. That she, you know, the commission assumed or said that she suggested it, but she never testified that I don't believe an injury ever occurred. So again, I'll go back to these two doctors. You want to knock out Dr. Young, you can't knock out Dr. Novak. Gave competent evidence, legally sufficient under Holly, to say that this was not related. Ms. Hendrickson talked about Perez and Gonzalez. I would disagree with some about the weighing of the evidence. In both Perez and in Gonzalez, defendants didn't put forth any evidence. So I don't know what weighing could go on between competing physicians. In the McLeod case, yes, it is, they do talk about weighing it, but again, I'll go back to, if you go back to my framework of you rebut the presumption, then you move on to the second stage of where you can weigh the evidence. You know, Judge Stroud said, even assuming arguendo, the doctor's testimony was found to be credible, then the full commission clearly didn't give it any weight. And that's what they should have done, and what I'm saying is perfectly fine if you all want to do it in this case, which is we rebutted the presumption, now weigh all the doctors. I don't think it's going to benefit the plaintiff, but you or the full commission can go back and weigh that evidence at that point in time. You know, the only unfortunate thing in the McLeod opinion is, yeah, Judge Stroud ends it by saying we don't err and determine that they rebutted the Parsons presumption. But again, I would say that case, it wouldn't have mattered anyway whether they rebutted it or not. The defendants were going to lose because once you weighed all the evidence.
Quick question. She said that you admitted the injury that he had, whatever injury he had back in 2010 was caused by the accident. So we don't, that's off the table according to her. So the only issue is whether or not the current injuries he's suffering is related to that injury. Doesn't matter whether that injury caused the accident or whether that injury he suffers now is from the same injury that he suffered back in 2010. Did you have a witness that said that that's not the case, or they just simply say we don't think that injury was caused by the accident? I know it's a fine distinction.
No, I'm saying, yes, both Dr. Novak, that's what I was trying to say is both Dr. Novak and Dr. Young said the current treatment that he is seeking today is not related to the 2010 event injury.
Whatever. Okay.
Right. And so, yes, nobody asked them the question, did the injury ever occur, or did the incident on this date result in an injury in 2010? No one ever asked either one of them that question.
I'll give you 1 minute to wrap up if you want to.
Well, that's all I had. I mean, so I'll just reiterate, I mean, unless there are other questions, again, I think we rebutted the presumption. That's the error that the full commission made, and like I said, in these cases, you can remand it back for the full commission to pick up at that point. I think that you have the authority, and I think the evidence is before you, that then you can move on and say, you know what, yeah, they rebutted the presumption, the burden of proof is on plaintiff, and plaintiff didn't meet that burden. Thank you.
Thank you so much. Thank you for your arguments. We'll take it under advisement.